Good evening, Professor Villa. My name is Felicia Orth, the hearing officer, and I understand we're going to move to your testimony. If you would please spell your name for the transcript.
Yes, Madam Hearing Officer. My name is Clifford J. Villa. Last name is spelled V as in Victor, I-L-L-A.
Thank you. And if you would raise your right hand, do you swear or affirm to tell the truth?
I do.
Thank you very much. Mr. Shemanek.
Thank you, Madam Hearing Officer. We'd like to go ahead and move Exhibit 6, which is Professor Villa's rebuttal testimony, and Exhibit 7, which is his CV, into evidence.
Thank you. They are admitted.
All right.
And Mr. Shemanek, your video is breaking up. I'm wondering if, although it's delightful to see you on screen, we may have to turn off the video.
I'm going to go ahead and turn it off. I do have rural internet, so bear with me. I apologize. Okay. Can you please state your name?
Yes, my name is Clifford J. Villa.
And please state on whose behalf you are submitting this rebuttal testimony.
I am submitting rebuttal testimony on behalf of the Center for Civic Policy and the NAVA Education Project.
Did you submit full written rebuttal testimony, and do you adopt it here without changes?
Yes, I do.
Is the Center for Civic Policy and the NAVA Education Project Exhibit 7 an accurate copy of your curriculum vitae?
Yes, it is.
And what is the purpose of your testimony today regarding this matter?
Three purposes. First, I'm offering rebuttal testimony to changes to NMED's proposed ozone precursor rule that have been submitted by NMOGA and supported by Mr. Smitherman in his direct testimony. Second, I'm responding to direct testimony offered in support of the proximity LDAR proposals by Hillary Hull, which identifies how a significant number of people from historically marginalized communities live in close proximity to low-producing wells and are at risk of health harms from oil and gas pollution due to this close proximity. Third, I'm responding to both of these proposals and testimony that decreased LIDAR specifically could put communities of color at risk. My testimony will note how federal and state regulators have failed historically to protect communities of color and low-income people from environmental harms in places including New Mexico. I will also explain how agencies and boards in New Mexico have legal authorities and duties to prevent such disproportionate harms in the future.
Professor Villa, you're speaking a little fast, and we're at the end of a long day. If you would just slow down a bit.
Thank you for the reminder, Madam Hearing Officer.
Will you please state your relevant education history?
Yes, I have a bachelor's degree in English and in economics from the University of New Mexico. I also have a law degree from Lewis and Clark Law School in Portland, Oregon.
Who is your current employer?
I am currently a professor of law with tenure at the University of New Mexico School of Law. However, I'm not representing UNM School of Law in my testimony today. Rather, I am testifying today based upon my independent expertise as a scholar in the field of environmental justice.
Please state your relevant prior employment history.
Prior to beginning as a tenure-track professor at the University of New Mexico in 2015, I served for more than 20 years as an attorney with the U.S. Environmental Protection Agency in offices of Washington, D.C., Denver, Colorado, and Seattle, Washington. I also taught as an adjunct professor at the Seattle University School of Law.
What were your relevant areas of work at the U.S. EPA?
As an EPA attorney, I worked with nearly all federal pollution control laws administered by the US EPA, including the Clean Air Act, the Clean Water Act, and the federal Superfund statute. I addressed concerns regarding hazardous pollutants, including volatile organic compounds such as benzene and toluene. I also focused heavily on incorporating environmental justice concerns into compliance and enforcement, ensuring protections for indigenous, immigrant, and low-income communities, for example.
Please describe your relevant scholarship, teaching, and your broader public engagement as a law professor.
In general, I teach in the areas of constitutional law and environmental law, and the intersection between the two in the field known as environmental justice. This has included teaching environmental law, environmental enforcement at both Seattle University and the University of New Mexico. At the University of New Mexico, I also teach a dedicated seminar on environmental justice. I'm also the co-author of a casebook on environmental law, and I'm the lead author and editor of a textbook on environmental justice that is being adopted by law schools now across the country. I also have several published articles in the field, um, on the field specifically concerning environmental justice. I've also made a number of professional presentations on environmental justice, including a presentation this past summer at the Rocky Mountain Mineral Law Foundation. I made presentations on environmental justice to EPA Region 10, to NMED, to tribal leaders, to federal judges, among many other audiences.
Did you review NMOGA's proposed changes to NMED's provisions for controlling leaks and fugitive emissions in proposed section 20.2.50.116, including specifically Mr. Smitherman's written testimony related to controlling emissions equipment leaks and fugitive emissions in the proposed section?
Yes, I did.
What did you notice generally about NMOGA's proposals as they compare to the NMED proposal?
In general, I noticed that NMOGA recognizes the necessity of additional leak detection and repair inspections for oil and gas facilities. However, NMOGA also proposes to reduce the frequency of LDAR inspections compared to proposals by NMED and also by Center for Civic Policy and NAVA Education Project.
Did you review the Center for Civic Policy and the NAVA Education Project's proposed changes to NMED's provisions for controlling emissions equipment's leaks and fugitive emissions in proposed section 20.2.50.116? And if so, what did you notice about the CCP and NAVA EP proposals as they compare to NMED's proposal?
Yes, I did review these proposals, and I noticed that the CCP and NAVA Education Project propose to increase the frequency of LDAR inspections for wellhead sites that are within 1,000 feet of occupied buildings.
Did you review Hillary Hull's testimony related to this LDAR proximity proposal to increase the frequency of LDAR inspections within 1,000 feet of occupied buildings? And if so, what did you generally notice about Mrs. Hull's testimony related to this LDAR proposal as it relates to the demographic impacts of the proposal?
Yes, I did review Ms. Hull's testimony, and I noticed that Ms. Hull testified that many New Mexicans belonging to historically marginalized social and economic groups live within 1,000 feet of affected wellhead sites, including approximately 2,700 children under the age of 5, more than 4,500 adults 65 years of age or older, more than 5,700 individuals who are living in poverty, and some 19,000 people of color, including over 5,800 Native Americans.
Did you also review testimony from Leanne Hill of PSC Health Energy? And if you did, what did you note generally about Mrs. Hill's testimony?
I did review Mrs. Hill's testimony, and I noted that she stated that there is a reasonable degree of scientific certainty that living in close proximity to oil and gas facilities results in increased health risks and impacts from elevated air pollution levels, and that these risks would be disproportionately experienced by people who live, work, and go to school near oil and gas facilities.
What observations did you make based on your review of these materials?
My overall observations were that there are a substantial number of people from historically marginalized communities who are particularly at risk of health harms from oil and gas infrastructure because of the close proximity to where they live, work, and attend school. I also observed that NMOCA's proposal would generally reduce the frequency of inspections for leaks at low potential to emit facilities compared to NMED's proposal. In contrast, CCP and NAVA Education Project proposal would increase the frequency of inspections of facilities that are in close proximity to where New Mexicans live, work, and attend school.
Can you describe what is meant by environmental justice?
Yes, Madam Hearing Officer, may I share my screen at this time?
Yes.
And I'd ask you to slow down again, please.
Thank you. I appreciate that important feedback. Can you all see a screen that says in the matter of proposed new regulation? Whoops. Yes.
Yes.
Okay. Thank you. Could you repeat the question, please?
Can you describe what is meant by environmental justice?
Yes. Turning to the next slide, you see a definition here that is maintained currently by the New Mexico Environment Department. It states that environmental justice means the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, and enforcement of environmental laws, regulations, and policies. This definition by the New Mexico Environment Department repeats verbatim the definition that has been maintained by the U.S. Environmental Protection Agency since at least the year 2000.
How do you believe this definition would apply to the present proceeding?
Well, three of the important elements of the definition of environmental justice are underlined in this slide. People in this definition applies to all people. It includes people of color, such as the estimated 19,000 people, including 5,800 Native Americans, in close proximity to wellhead sites. People also includes elderly people, young people, and people with pre-existing health conditions who may be more vulnerable to poor air quality. Meaningful involvement in this definition means that members of the interested and affected public, including members of CCP and NAVA Education Project, can not only provide public comments on a proposal, but have a genuine opportunity to influence the final outcome of this proceeding. And finally, fair treatment means, in the end, that no group of people, such as low income or indigenous people within 1,000 feet of a wellhead, will suffer disproportionate harms as a consequence of the regulated activity.
To your knowledge, has environmental injustice been a real problem in New Mexico?
Yes.
Can you give us some examples?
Yes. For example, in Espanola, there is a Superfund site known as the North Railroad Avenue plume. It is consisting of chlorinated solvents that are in the groundwater from a little dry cleaner. The plume was discovered in 1996, fully 25 years ago, and still contaminates the groundwater beneath downtown Espanola today. In that community, it's estimated that it's 93% people of color, including members of the Santa Clara Pueblo. In the village of Cuesta, north of Taos, the groundwater is contaminated by what is known today as the Chevron Cuesta Superfund site. Groundwater contamination reaches beneath the entire village and has, in fact, affected the health of many villagers, according to some estimates. The village of Cuesta is 80% nationally ranked for people of color. In the South Valley of Albuquerque, where my family is from, it is heavily immigrant and Latino. It has multiple Superfund sites, multiple sources of industrial air pollution. And in the South Valley of Albuquerque, life expectancy is 10 years or less than other neighborhoods in Bernalillo County. And a final example comes from the Grants Mining District, where there are elevated cases of lung cancer among Native Americans associated with occupational and residential exposures due to historic uranium mining.
In your expert opinion, does the Environmental Improvement Board have the legal authority to consider disparate impacts of pollution in promulgating regulations under the Air Quality Control Act?
Yes. In my analysis, the Environmental Improvement Board must consider and give weight to the disparate impacts of pollution in promulgating regulations under the Air Quality Control Act, under the text of the statutes and relevant case law, including those indicated in the slide on the screen. just to move forward. So the authority of the EIB to address concerns for environmental justice is amply demonstrated in this case known as Colonias Development Council versus Rhino Environmental Services. And it demonstrates how New Mexico agencies have both the legal authority and a legal duty to take environmental justice into account in their agency decisions. In this case, decided in 2005, the New Mexico Supreme Court directed the Secretary of NMED to consider public testimony opposing a proposed landfill, even if the public comments concerned issues of public health and welfare beyond the technical requirements for a landfill. The Rhino case specifically concerned the New Mexico Solid Waste Act. However, per an opinion from the New Mexico Attorney General in 2008, Rhino also demonstrates that the same result could and should be reached under the Air Quality Control Act. The Attorney General observed in writing that the Air Quality Control Act, like the Solid Waste Act, is replete with references to public input. The Air Quality Control Act also provides sufficient statutory authorization, like the Solid Waste Act, for the promulgation of regulations involving the consideration of public health and welfare. The Attorney General concluded that, therefore, pursuant to the Rhino Roadmap, the promulgation of regulations under the Air Quality Control Act, quote, will allow board staff in the future to assign weight to public testimony regarding environmental justice principles. Taking just a closer look at the text of the Air Quality Control Act, it says, among other things, that the EIB, quote, shall give weight it deems appropriate to all facts and circumstances. It also says that the EIB must consider the, quote, character and degree of injury to or interference with health and welfare.
Can you expand on what character and degree of injury means based on how the phrase has been used and understood in other contexts?
Yes, character and degree of injury to health and welfare must include consideration of whether a proposed regulation or activity would result in disparate harms to low-income communities or communities of color. Just skipping forward a couple of slides, there is a recent case that I mentioned in my rebuttal testimony, Friends of Buckingham versus Virginia Air Pollution Control Board, decided just last year by the Fourth Circuit Court of Appeals. In this case, the court looked at language very similar to that in New Mexico that required the state of Virginia to consider the character and degree of injury. When the Virginia Air Pollution Control Board approved permitting for a compressor station that was on a proposed pipeline, the court concluded that the Virginia Air Pollution Control Board had failed to satisfy the requirement for evaluating character and degree of injury when it failed to accurately determine the demographics of the community and failed to determine the actual threats to that community posed by the proposed facility.
Beyond the Air Quality Control Act, are there any other legal authorities that help establish the board's duty to consider environmental justice?
Yes. Another of those legal authorities appears on the slide here. That is the Civil Rights Act of 1964, Title VI. Title VI of the Civil Rights Act applies to any program or activity receiving federal financial assistance. The New Mexico Environment Department is a program that receives federal financial assistance. And so this provision of the Civil Rights Act applies to NMED activities. And for any program that receives this federal financial assistance, the statute provides that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination. Now, this statute is also elaborated upon in a series of implementing regulations. The regulations implementing the statute, including regulations promulgated by the EPA, prohibit agencies who receive federal aid from, quote, using criteria or methods of administering its program or activity which have the effect of subjecting individuals to discrimination because of their race, color, national origin, or sex, or have the effect of defeating or substantially impairing accomplishment of the objectives of the program. So the regulations apply not only to discriminatory acts, but also acts that end up having some sort of discriminatory effect. Now, enforcement of the statute is not available directly in federal court. For alleged violation of the statute and its regulations, parties who complain can file an administrative complaint with the US EPA. There have been, in fact, a number of administrative complaints filed against NMED and other agencies, including the city of Albuquerque, uh, alleging violations of the statute and regulations. For example, in the year 2002, a Title VI complaint was filed against NMED for alleged discriminatory effect in the permitting of a hazardous waste facility east of Roswell. The administrative complaint was finally resolved through an informal resolution agreement entered 15 years later in 2017, which provides some indication of how serious some of these actions may be considered.
Do you have any other legal authorities?
Yes, another legal authority arises under executive orders requiring agencies, federal and state, to take environmental justice considerations into account in their activities. In 1994, President Bill Clinton signed Executive Order 12898, which, among other things, required all federal agencies to ensure that their programs, plans, and activities do not have the effect of excluding persons from the benefits of the agency's actions and subjecting them to discrimination. Now, this executive order applies to all federal agencies. There is also an executive order signed in 2005 by New Mexico Governor Bill Richardson that provides equal obligations for New Mexico agencies and boards to also pursue environmental justice.
What do these executive orders require?
Well, looking at just a few of the provisions from the New Mexico Executive Order on Environmental Justice, looking at paragraph 1, it says that all cabinet level departments and boards and commissions that are involved in decisions that may affect environmental quality and public health shall provide meaningful opportunities for involvement of all people, regardless of race, color, ethnicity, religion, income, or education level. Paragraph 3, indicated here, notes that all relevant cabinet level departments and boards and commissions shall utilize available environmental and public health data to address impacts in low income communities and communities of color. And we have seen a number of environmental and public health data that has been discussed in testimony this afternoon and this evening. And under the executive order, it would require all cabinet level departments and boards to take that data into account in making decisions concerning environmental and industrial facilities.
Are violations of these executive orders directly enforceable?
Violations of the executive orders are not directly enforceable. However, if you look at paragraph 7 here on the slide, you find this sort of savings clause in both the federal and state executive orders on environmental justice. This one says from the state of New Mexico, nothing in this executive order is intended to create a private right of action to enforce any provision of this order or any action plan developed pursuant to this order. So the order themselves do not give rise to an enforceable action.
So what is the legal significance of these executive orders today?
Well, as indicated in the case that I already mentioned, Friends of Buckingham versus Virginia Air Pollution Control Board, even though the executive orders themselves are not directly enforceable, courts have found that the executive orders today establish enforceable standards of conduct for both federal and state agencies. In a forthcoming article to be published by NYU, I trace the development of this robust body of case law, including Friends of Buckingham, decided last year by the Fourth Circuit Court of Appeals. The DC Circuit, through many decisions, including concerning the Dakota Access Pipeline, has also affirmed these legal principles. Most recently, just last month, Another pipeline project proposed in Texas was struck down based upon failure to conduct a proper environmental justice analysis. And finally, all of this leads today to the conclusion reached last year by the Fourth Circuit that environmental justice is not merely a box to be checked. Based upon the case law over almost 30 years now, we can see that environmental justice is no longer a theory. It's not a fad. It's not just a good idea. Environmental justice is now the law. And as a teacher of environmental justice, I want to help people, including members of the EIB, understand that law and fulfill their statutory duty to serve the public interest for all New Mexicans.
Do you have any recommendations to the board for this regulation based on environmental justice principles and the testimony that you've reviewed?
Yes, I would recommend that the board reject any proposals for changes to the regulation that would have the potential to disparately harm marginalized populations, particularly communities of color. I would also recommend that the board accept any reasonable proposals that would further protect marginalized populations from health harms. I have reviewed the proposals for changes to the regulation from NMOGA, and I see they include proposals to subject low potential to emit wells to less frequent leak detection inspections. I also understand from testimony by Hillary Hull that many people of color, including Native Americans, live in close proximity to such wells. I therefore recommend that in keeping with environmental justice principles, the EIB reject proposals for reduced inspections of wellhead proposals. I've also reviewed the proposals from the coalition of nonprofit organizations, including CCP and NAVA Education Project, that would require more frequent leak detection and repair for wellhead sites within 1,000 feet of occupied buildings. And I have reviewed the rebuttal testimony from Leanne Hill, stating that there's a reasonable degree of scientific certainty that living in close proximity to oil and gas facilities results in increased health risks. Because many of the people who live in close proximity to these wells are people of color, I therefore recommend the EIB adopt those provisions in keeping with the principles of environmental justice. This concludes my rebuttal testimony.
Madam Hearing Officer, this concludes a summary testimony of Professor Clavia, and we now open him up for cross-examination.
Thank you very much, Professor Villa and Mr. Shemanek. If you would stop sharing your screen momentarily, Professor.
Yes. Hello.
Thank you. If there's any party, I think I see Mr. DeSalen, who wishes to question Professor Villa, turn on your screen. We'll start with you, Mr. DeSalen.
Thank you, Madam Hearing Officer. Can you hear me okay?
Yes, sir. Thank you.
Okay. Good evening, Professor Villa. Just for the record, my name is Charles DeSalen. I'm an attorney representing the New Mexico Environmental Law Center. I just have a couple of quick questions for you. You talked about the Rhino decision in your testimony.
Yes.
And you mentioned that there was an Attorney General opinion that applied the holding of the Rhino decision to the Air Quality Control Act. Was that your testimony?
Yes.
Are you familiar with a New Mexico State District Court case that similarly applied the holding of the Rhino decision to the Air Quality Control Act?
I may, although I'm not sure I'm thinking of the one you were.
Okay.
Provide a little more information.
I'm thinking in particular of a case last year, Southwest Organizing Project versus Albuquerque Bernalillo County Water Quality Control Commission, or excuse me, Air Quality Control Board.
Mm-hmm. Yes.
Could you elaborate on that a little bit?
Well, I believe the case arose from the Albuquerque South Valley, which I described earlier in my testimony, which is a community that is experiencing multiple forms of pollution. It may be that the pollution is coming from facilities that are subject to permits, and may even be that the pollution is coming from facilities that are in compliance with applicable permits. The question there is often one of cumulative impacts on those communities. Again, that community is very low income and very diverse, heavily people of color. And of course, they have concerns about protecting their own health, even if those facilities are in compliance with their individual permits.
Thank you, Professor Villa. That's all the questions I have.
Thank you, Mr. DeSalem. Mr. Rose?
Just a couple of questions for clarification. Professor Villa, my understanding is that the Environmental Law Clinic is representing the parties you're testifying on behalf of in this hearing. Is that correct?
Yes, that's my understanding.
And do you have an attorney-client relationship with those parties, or is your testimony independent of that representation?
I am not in this capacity representing the clients in this case. I do, in my faculty capacity, rotate into that clinic, although I've had no direct engagement as an attorney in this particular proceeding.
And with respect to Mr. DeSalen's comment, and are you aware of the Court of Appeals case dealing with Southwest Organizing Project's challenge to an air permit with the city of Albuquerque and rejection, I believe rejection of the cumulative impacts requirement that in that case, the Albuquerque Air Board consider?
Yes, I am familiar with that.
And that was a permitting decision, correct?
I believe it was.
And this is a rulemaking decision, rulemaking matter?
Yes, that's my understanding.
And are you testifying that this board has the authority as a matter of state law to require to impose requirements that are more stringent than necessary to meet the federal ambient air quality standard for ozone?
My testimony is that this board has authority and an affirmative duty to protect the health of all New Mexicans. The language and the definition of environmental justice is actually all people. And whatever it may take to protect those people, that is the requirement of environmental justice.
And are you recommending to the board that if the notice of this proceeding did not include some of the language you were talking about, or notice of that it's appropriate for the board to in fact act without giving notice to others who might be affected?
I'm not making any proposal for rulemaking that's not already stated in my written testimony.
And do you know whether, is it your opinion that the notice of this proceeding allows the board to consider those proposals?
I could read the notice of this proceeding. Like anybody else, I understand the notice of proceeding applies to emission standards for volatile organic compounds and oxides of nitrogen for oil and gas production, processing, and transmission sources.
And if you read the rest of the notice, I think it goes on to say it implements a provision of the state statute related to assuring that the federal ozone NAAQS is met.
I'm sure the notice will speak for itself.
And I was just wondering whether your opinion included an examination of the notice and an opinion on whether or not the notice that this board is operating under is sufficient to include the proposals you testified on.
My testimony is really related to the authority and duty of this board to serve the interests of environmental justice and protecting all people in the state of New Mexico.
And is it your opinion that the federal ozone national ambient air quality standard does not and somehow affect all people equally?
Well, we've heard a good bit of testimony today that proximity to sources of air pollution can have a significant effect on human health. We've heard testimony from Dr. Thompson and others who've testified to that point. I am not here to testify specifically about medical issues, but I think we've heard testimony to that effect today.
And is it your opinion that this board has the authority to adopt requirements more stringent than the federal national ambient air quality standards in this proceeding?
Well, I think one thing we know, as we've heard today, is that the NAAQS for criteria pollutants have become more stringent over time. And in fact, I know that there have been a number of concerns where people have referred to a national standard as suggesting that that ensures compliance with in protection of public health. The Friends of Buckingham case was actually a case directly on point. It appeared that the particular county in Virginia was in compliance with the NACs. However, people who lived right next to the proposed facility could have been certainly threatened because they might have been breathing more polluted air than would have been detected when you apply the NACs over a large area like an airshed.
Do you know whether or not there's a proposal before this board to adopt a standard for ozone more stringent than the NACs?
I'm not aware of that.
Thank you, Madam Hearing Officer. I have no further questions.
All right, thank you. Let me invite any other party with a question of Professor Villa to turn on their camera. No? I'll turn then to questions from the board. While I'm doing that, if you're an attendee on this platform and would have a question, please reach out through the chat. Madam Chair, do you have questions of Professor Villa?
Thank you, Madam Hearing Officer. And I think I just want to clarify, good afternoon or good evening, Professor Villa. Appreciate your testimony and thank you for staying with us at this late hour.
Thank you.
So kind of to follow up on Mr. Rose's line of questioning, I think he was talking about not more stringent than the NACs, federal EPA NACs levels. But in my understanding, in terms of the proposals that have been put forth, would be more stringent in terms of, say, the LDAR proposed requirements that would accomplish or would address some of the environmental justice concerns?
Yes, thank you for the question, Madam Chair. So I am not proposing any changes to a national standard that is set by EPA. But the National Ambient Air Quality Standards are really measured as a measurement of air pollution in the ambient air and measured over large geographic areas like a county or an airshed. As I understand the proposal that we're discussing in this proceeding, it's not about changing a national standard. It's about how you achieve that national standard. And one way to achieve it is by preventing emissions of air pollutants, specifically the ones at issue in this case, so that you don't exceed those national standards.
Thank you for that response. And if I can just kind of clarify, so some of the proposals, I think that you mentioned your review of in close proximity, some of the close proximity proposals, would that address some of the environmental justice concerns?
Yes, and I appreciate the question too. I mean, the NACs may be one standard to consider in protecting human health. Another standard to consider is just the actual absolute pollutants that people are breathing if, for example, they live right next to a facility. The national standard won't tell you whether or not health of any individual family or household is being protected. What will tell you that is monitoring and inspections of the actual emissions from an individual facility.
Okay, thank you so much, Professor Villa and Madam Chair. That's all I have for now.
Thank you.
Thank you. Vice Chair Trujillo Davis.
I don't have any questions at this time. I'd just like to thank Mr. Villa for taking the time to speak with us.
Thank you, Madam Vice Chair.
Member Bitzer?
I have no questions. Thank you.
Thank you. Member Garcia? Not sure that I see her anymore. And Member Honker, I think. All right. Let's see. Does any of that prompt redirect for you, Mr. Shemanek?
No, I believe that would conclude all our testimony tonight. Thank you.
All right, thank you. Thank you very much, Professor Villa and Mr. Shemanek.
Thank you, Madam Hearing Officer. Good night.
Good night. Ms. Katz, we apparently do not have Mr. Blewett testifying on this topic, and we don't have Ms. Hill until tomorrow morning. I'm wondering if there's anything further tonight from Ms. Keene, or if you want to wait.
I think that we can, I'd like to just put Ms. Keene and Mr. Palmer up to try to wrap up our case this evening.
All right.
It's not very much.
All right. Thank you.
All right. Okay. So beginning with Ms. Keene, what is the department's response to the environmental NGO's proposal for increased leak monitoring at wells located near occupied structures?
The department supports the proposal, and we note that EDF has put on evidence demonstrating health impacts based on proximity, and that Colorado has adopted similar provisions in their Regulation 7. And the department believes that this is the right thing to do, and we think that industry should agree to the proposal.
Thank you. And moving to Oxy's testimony, what is the department's position regarding exempting satellite facilities from the LDAR requirements as proposed by Oxy?
The department does not agree that satellite facilities should be exempt from the LDAR requirements. Oxy did not provide any emissions data on those types of facilities, and NMED was unable to determine the implications of exempting those types of facilities. If this is a low emitting facility, the rule already provides for a reduced LDAR frequency based on PTE.
Thank you. And so moving to Namoga's testimony, Mr. Smitherman stated that the AVO requirements in the Oil Conservation Division rule do not align with the department's AVO requirements in its proposed rule. What is your response to that statement?
The department's proposal requires weekly and monthly AVO inspections depending on a facility's oil or gas throughput. OCD's regulation requires weekly and monthly AVO inspections based on gas throughput. So these rules are aligned for gas throughput, and it was appropriate for OCD to base their requirement on gas throughput because that the intent of that rule is to reduce the waste of gas. It is not appropriate to delete oil throughput from this draft rule, as that would exempt from AVO inspections those wells that are primarily oil producing wells with low natural gas production. Oil wells with low gas production are sources of VOC emissions, and the purpose of the AVO inspection is to find and fix those sources of leaking VOC emissions. Thus, it is not appropriate to strike the oil throughput threshold from this requirement.
Thank you. Mr. Smitherman said that NMOGA would be happy to gather cost information from New Mexico operators that would be representative of actual New Mexico operations. Did the department send out a survey to operators following the methane advisory panel process in order to gather this type of New Mexico specific data?
Yes.
And what was the response rate to that survey?
0 response.
Did NMED propose the LDAR frequencies that are currently before the board on May 6th with its petition for rulemaking?
Yes.
And could NMOGA have collected the information from its members and provided it for the board's consideration over the past 4.5 months?
Yes.
Regarding Mr. Smitherman's suggestion that NMED should allow compliance with the federal requirements to suffice, if those requirements, regarding that statement, if those requirements were sufficient, would we be seeing the rising ozone levels that we are?
No,
And is it necessary to have more stringent state rules to address that issue as authorized by the statute?
yes.
Thank you. And turning to Mr. Palmer, Mr. Smitherman characterized ERG's analysis regarding the LDAR provisions as having errors. In any of his direct or rebuttal, did Mr. Smitherman identify any actual errors in the NMED and ERG methodology?
No, he did not. The NMED analysis used the federal EPA's control technique guideline analysis that was published in 2016 and is still the guidance offered to states to develop rules for existing sources of VOC in the oil and gas industry.
Thank you. And does the CTG present incremental costs for different LDAR frequencies or recommend that states evaluate incremental costs?
No, it does not.
Thank you. That is all I have on this rebuttal.
Thank you, Ms. King, Mr. Palmer, and Ms. Katz. If there are any parties with questions of the Environment Department panel, I see you, Mr. Rose.
Madam Hearing Officer, my question is actually more for counsel and for the witnesses, and I just wanted some clarification that I think Ms. Keene testified about the proposals being more stringent than federal requirements, and I was curious as to how the department saw procedurally this board was going to look at that and whether it was going to have this hearing or a separate hearing that would be directed to the determination required by the state statute that based on substantial evidence after notice and public hearing, that the proposed rules will be more protective of public health and the environment. Is it the department's position that this proceeding satisfies that, or that some separate proceeding specific to the proposals would be necessary?
Mr. Rose, we are not relying specifically on that provision. The provision in what is currently paragraph C of 74-2-5 authorizes the board to adopt more stringent regulations to address rising ozone concentrations in areas of the state that are exceeding 95% of the NAAQS.
Thank you, Madam Hearing Officer.
Thank you. Oops. Are there any other parties with questions of the department? Not seeing anyone else. Turn to questions from the board. While I'm doing that, if you're an attendee on the platform and have a question, reach out through the chat. Madam Chair, do you have questions?
Thank you, Madam Hearing Officer. I just want to thank our witnesses for sticking with us and Ms. Katz for hanging in there. I have no questions at this time.
Thank you. Vice Chair Trujillo Davis.
I want to echo Member Sweena's sentiments there, and thank you. I don't have any questions right now.
Thank you. Member Bitzer.
No questions, thank you.
Thank you very much. Thank you, Ms. Katz, Ms. Keene, and Mr. Palmer. I believe that completes as much of the topic as we can this evening, and we'll hear from Ms. Hill in the morning. So, wait, Ms. Fox.
Thank you, Madam Hearing Officer. We were wondering if we could be heard on Mr. Rose's objections to our exhibits tomorrow morning before Ms. Hill goes on. They object to a number of our exhibits and testimony, and she is one of them, and we would like to put this objection to rest.
Is 8:30 okay for the lawyers again? Yeah, I see Ms. Katz nodding, Ms. Fox. Let's see, Mr. Rose? Mr. Rose?
Madam Hearing Officer, yes,
Yeah.
I'm getting there. I'm just slow at this time of night. I thought we put the issue to bed and that we'd address it in our post-hearing submittals, but I can certainly make the same argument. And as I think I've responded to Ms. Fox, if we've stipulated as to the admissibility subject to objection, if they want you to rule on the objection, if you rule against me, I'm going to raise it again in post-hearing submittals anyway. So I don't think that we gain anything in terms of time or particularly in finishing this hearing by doing it that way, but I can certainly do that if that's appropriate.
All right, so Mr. Rose, I've been very careful for about 20 years now not to make recommendations to boards or commissions on the merits of a petition, but I guess I feel like I would still like an opportunity to make recommendations on the admissibility of evidence. So let's go at 8:30. And let's see, Vice Chair Davis,
Thank you.
so do you have a question you want to put on the record? No, okay. I think we're done for this evening then. Thank you all very much for hanging in there with us. And I'll be on the call with the lawyers at 8:30. Good night.